Good morning, students. Today we are going to review the questions you have taken on contingent and quasi contract. To start with, let me give you an introduction about contingent contract. According to section 31 of Indian Contract Act, contingent contract is a contract to do something or not to do something. To illustrate contract of insurance, it should be noted that the performance of contingent contract is made dependent on happening or non-happening of a particular event, and such contingent event should not be the mere will of the promiser. Now, to give an example, if X agrees to pay Mr. Y, if he wishes, it is not a contingent contract because it is at the mere will of Mr. X. But on the other hand, if Mr. A promises to pay Mr. B, if he leaves to Bombay, then it is a contingent contract because it is dependent on whether he leaves to Bombay or not. Similarly, if a contingent contract is made based on happening of an uncertain future event, it can only be enforced if such event happens. On the other hand, if contingent contract is made based on non-happening of an uncertain future event, it can be enforced only if happening of such event becomes impossible. So, an event will be considered to be impossible even if there is a chance of a person to act on unspecified time. That is, example, assume that A agrees to pay B a sum of money if A marries C, but C marries D. The marriage of A to C is now to be considered impossible, although it is possible that D may die and after that C may marry A. So, to consolidate and finalize, one point to be remembered is agreement to do an impossible event is void because such event is impossible, and contingent contract is dependent on happening or non-happening of an event, which means there is an equal chance of happening, or at least there is a minute chance of happening or non-happening of an event. So once a event is considered to be impossible to happen, then that such contract is not a contingent contract, it is void. Now let us go to quasi contract. The word quasi means representing, hence quasi contract also means representing a contract. It must be noted that quasi contract do not arise out of any agreement of the parties concerned, and it is imposed by law. Also, rights against the quasi contracts are available only for a particular person, not to the rest of the world. And according to quasi contract, if necessaries are supplied to a person who is incapable of contracting, example minor or a person of unsound mind, the supplier is entitled to claim the price from the property of such person. And also, in other case, say if a person does anything for another person without an intention to do it gratuitously, he is eligible for compensation if he proves that he has done the act lawfully and without an intention to do it gratuitously. And under quasi contract, the responsibility of a person finding the goods belonging to others is similar to that of a bailee. Hence, he must take care of the goods properly. And where certain goods are delivered by mistake or under coercion, then such person must repay it. Now, it is also important to understand the difference between wagering agreement and contingent contract. And please do know that wagering agreement is different from contingent contract, and wagering agreement is a promise to give money or money's worth upon the determination or ascertainment of an uncertain event. A wagering agreement is void, whereas contingent contract is valid. Now with this introduction, and also please know that quasi contract is also based on the law of unjust enrichment to others, so which you would have read in the theories. And with this introduction, let us move on to the review questions. A quasi contract is a contract dash by law. Option A is not enforceable, option B is imposed, option C voidable, and option D is made. The correct option is option B. As I said in the introductory section itself, a contingent contract is imposed by law. It is not a contract, it's not an agreement which is entered between two or more parties, written or oral or implied or in any other way. Law imposes such contract on parties based on unjust enrichment. Second question. A agrees to pay rupees 1 lakh to B if he brings on earth a star from sky. This is a dash. Option A, an illegal agreement. Option B, a valid agreement. Option C, a voidable agreement. Option D, a void agreement. The correct option is option D, a void agreement. Please do understand, any agreement to do things which are not possible is void. To classify a contract as contingent contract, there should be an element of possibility to do the act. Bringing a star to earth is impossible event and hence it is void. Question number 3. Finder of lost goods is entitled to be reimbursed for any lawful expenses incurred for option A, tracing the true owner. Option B, taking care of the goods. Option C, selling the goods if they are in a deteriorating condition. All of the above. When we look up the options, the correct option is option D, all of the above. The responsibility of finder of lost goods is already discussed, which is equal to responsibility of a bailee, wherein he is entitled to be reimbursed for lawful expenses incurred for tracing the true owner, expenses incurred for taking care of the goods, expenses incurred for selling the goods if they are in deteriorating condition, and hence the answer is all of above. Question number 4. X saves Y's property from fire. X is entitled to compensation from Y if the circumstances show that X intended to act A, gratuitously, B, non-gratuitously, C, either A or B, D, neither A nor B. The answer is B, non-gratuitously. So the reason is Section 70 of Indian Contract Act says that where a person lawfully does anything for another person or delivers anything to him, not intending to do gratuitously, then such other person who enjoys the benefit is bound to make compensation to the former in respect of or to restore the thing so done or delivered, and hence the answer is non-gratuitously. Which one of the following is a contingent contract? Option A bets on a horse and if the horse wins the race he will get rupees 10,000. Option B, A sells his property subject to condition that the property will be reconveyed to him on repayment of price with interest. Option C, a god is appointed at swimming pool for the sole purpose of rescuing drowning persons. Option D, a borrower solemnly promises to pay off the lender when the borrower has funds. The correct answer is option B. A sells his property subject to condition that the property will be reconvened to him on payment of price with interest. When you look at the other options, option A is a wagering contract and hence not contingent contract. Option C is the god is already appointed and his appointment is not anymore contingent and hence his act of rescuing is only contingent, which is not a contract, and hence it is not contingent. On option D is a borrower solemnly promises to pay off the lender when the borrower has funds. This is not a contingent contract because he has already borrowed the money and the condition is only for the repayment, and hence option B, which says A sells his property subject to the condition. Once the word condition is there, then it is a contingent contract provided it is lawful, and hence the property to be reconvened to him on repayment of price with interest is a contingent contract. Question number 6. A promises to pay B a sum of money if certain ship does not return within a year. What are the consequences? A. The contract may be enforced if the ship does not return within the year. B. The contract can be enforced if the ship is burnt within the year. C. The contract may be repudiated. D. Answer A and B above. The correct answer is D. Answer A and B above. The reason is section 31 says a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen, and hence the contract here is that A promises to pay B if ship does not return within a year. So hence the contract may be enforced if ship is not returning. Also there is no possibility of the ship to return, and hence according to option B the ship is burnt within a year. Hence within a year there is no chance of ship returning to the shore, and hence option D is correct. Question number 7. A finder of goods, option A, can sell the perishable goods if true owner cannot be found, becomes the owner of goods and hence can use them. Option C, can destroy the goods, and option D, use them for his own purpose. The correct answer is option A. Can sell the perishable goods if true owner cannot be found. A finder of goods, as discussed, has the responsibility similar to that of bailey, and hence he cannot become the owner of goods and who is entitled to use them. Also, he cannot destroy the goods or use them for his own purposes. Hence, he has to properly take care of the goods, and in case if the goods are in perishable condition, and if the true owner cannot be traced, he can sell the goods. And hence, the correct answer is option A. Question number 8. A contract of insurance, option A, is an invalid contract. Option B, a contingent contract. Option C, a quasi contract. Option D, an agency contract. The correct answer is option B, a contingent contract. The contract of insurance generally is a contract which provides the person which covers the risk of the person in case of any happening of any uncertain event. The insured is compensated for his loss. Hence it is highly dependent on happening of the uncertain event, and hence it is a contingent contract. Anyway, quasi contract, agency contract are not within the purview of insurance contract, and insurance contract is a valid contract, and there is no question of choosing option A. Hence the correct answer is option B, a contingent contract. Question number 9. Where a person finds goods belonging to other person, he, option A, can use the goods as his own. Option B, can sell them if they are perishable. Option C, should trace the true owner and return the goods to him. Option D, B and C both. The correct answer is option D, B and C both. So when a person finds goods belonging to others, as I told, it is once again a contract of similar to the contract of bailment, and the responsibility of finder of lost goods is similar to the responsibility of bailey, and hence he can sell them if they are perishable, as discussed. If else if he has the option of tracing the true owner, he has to trace the true owner and return the goods to him, and hence the answer is option D. Question number 10. Quasi contracts rest on the ground of equity, lawful consideration, relation of the parties. Option D, contingencies. The correct answer is option A, equity. This is since quasi contract is imposed by law, there is no special agreement between two parties to enter into quasi contract. Law based on the ground of equity and justice imposes quasi contract upon the parties, and hence the option is A, equity. Question number 11. If an obligation created by quasi contract has not been discharged, then the injured party becomes entitled to receive compensation from a party in default. The options are A, yes, as section 73 makes a provision in this regard. B, no, as section 73 simply makes it enforceable without compensation. C, yes, section 73 makes a conditional restricted provision in this regard. Option D, none of these. The correct answer is option A. Yes, as section 73 makes a provision in this regard. So section 73 makes a provision that if an obligation created by quasi contract has not been discharged, the injured party becomes entitled to receive compensation from the party in default, and hence the option is A. Now going to question number 12. A quasi contract under the Indian contract is, the options are A is an agreement, B is a contract, C has only a legal obligation, D is not any of the three. The correct option is has only a legal obligation. So the quasi contract, as I told, is not an agreement between the parties. It is not a contract because it is a quasi contract. The meaning for the word quasi is representing. It is representing a contract. The parties to the contract has some legal obligation. For example, a person who is supplying the necessities to a person who is not capable of entering into the contract has to be reimbursed with the price from the property of the incapable person. This is a legal obligation. This is not a contract. So hence quasi contract as imposed by law has only a legal obligation. Going to question number 13. A person who finds goods belonging to another and takes them into custody is subject to the same responsibility as that of bailey. A true, B partly true, C false, and D partly false. This is already discussed and the answer is true. A contingent contract is void, voidable, valid, and illegal. So the answer should be a contingent contract is valid because it is not, it is a law creates legal obligation on behalf of the parties, and such obligation are valid in law, and hence the answer is valid. Question number 15. The features of quasi contract are as follows. Option A, such contracts do not arise from any agreement of the concerned parties. It is imposed by law. Option B, such a right is always a right to money, very often right to liquidated sum of money. And option C, it is a right available against a particular person or persons only, not against the world as large. On option D, all of the above. The answer is option D, all of the above. Sometimes the law implies a promise imposing obligation on one party and conferring right in favor of another. Even when there is no offer, no acceptance, no free consent, and in fact there is neither agreement or promise, such cases are not contract in such strict sense, but the court recognizes them as relations resembling those of contracts and enforces them as if they were contracts. They are hence termed as quasi contract. So quasi contracts are based on principles of equity, justice, and good conscience. Hence the answer is all of above. Quasi contract arise. Option A, where obligation are created without contract. Option B, where obligation are created under a contract. Option C, out of natural causes. And option D, out of man-made causes. The correct answer is option A, where obligations are created without a contract. So as discussed, for quasi contract there is no literal contract between parties. Law creates the contract, creates an obligation on behalf of the parties. Question number 17. A agrees to pay 10,000 to B if it rains, and B promises to pay a like amount to A if it does not rain. This agreement is called A. Quasi contract. B. Contingent contract. C. Wagering agreement. And D. It is voidable agreement. So the correct answer is C. It's wagering agreement, because here section it is governed by section 30, which says a wagering agreement is an agreement between two parties where one party promises to pay money or money's worth on happening of some uncertain event in consideration of other parties' promise pay if the event does not happen. And hence, since there is money or money's worth involved in that based on happening of an event, it is a wagering agreement. Now let us go to question number 18. A agrees to pay a sum of money to B if certain ship does not return. The ship is sunk. A refuses to pay. What will be the advice to B? B cannot. Option A. B cannot enforce the contract. Option B. B can enforce the contract when the ship sinks. Option C. B can sue for damage. And option D. B can sue for non-fulfilling the promise. The correct answer is option B. So a contingent contract is a contract to do or not to do something. If some event collateral to such contract does not happen, then contingent contract are still valid. I mean, it's a valid contract. Here A agrees to pay a sum of money to B if certain ship does not return. The ship sunk. A refuses to pay. What will be the advice to B? Hence the ship has sunk. It is obvious that the ship is not going to return anymore, and hence B can enforce the contract when the ship sinks. When the ship sinks, and B need not wait till the time given by A. Question number 17. A agrees to pay 1000 to B if it rains, and B promises to pay a like amount to A if it does. Question number 19. Which is not true in case of finder of goods? He can sell goods if the owner cannot be found. If the owner is found and he refuses to pay lawful charges, and he can sell the goods if the goods are not perishing in nature, and he cannot sell the goods in any condition. The correct answer is option D. He cannot sell the goods in any condition. So the finder of this is governed by section 169. That is, the finder of can sell the goods in the following cases. That is, when a thing is found in danger or perishing, danger of perishing, and when the owner cannot with reasonable diligence be found out, when the owner is found out but he refuses to pay the lawful charges to the finder, and when the lawful charges of the finder in respect of thing is found, it amounts to 2/3 of value of thing found, and hence the option is D. Going to question number 20. Dash is an agreement between two parties by which one promises to pay money or money's worth on the happening of some uncertain event in consideration of the other party's promise to pay if the event does not happen. The options are A. Quasi contract, B. Contingent contract, C. Wagering agreement, and D. Voidable agreement. The correct answer is C. Wagering agreement. This is according to Indian Contract Act, the definition of wagering agreement, wherein a wagering agreement is an agreement between two parties where one promises to pay money or money's worth on happening of some uncertain event in consideration of other parties' promise to pay if the event does not happen. The major difference between wagering agreement and contingent contract is, barring that wagering agreement is void and contingent contract is valid, there is the based on the happening or non-happening, the outflow of money or money's consideration is highly present in wagering agreement, but in contingent contract, the enforcement of contract is based on happening or non-happening of a particular event, and hence in this case there is a outflow of money or money's worth on happening of some uncertain event, and hence it is wagering agreement and not contingent contract. Going to question number 21. The quasi contracts includes A. Payment by an interested person, liability to pay a non-gratuitous act, both A and B, neither A nor B. The correct answer is C, both A and B. The quasi contract includes both the payment made by interested person and also liability to pay for a non-gratuitous act, and hence it is C. Question number 22. Which of the following constitute responsibility of finder of lost goods? Option A, he shall take responsible steps to trace the owner. He shall take care of goods. Option C, if the goods are in a deteriorated or wrong condition, sell them off and remit the proceeds to the owner. Option D, all of the above. Answer to the question is all of the above. So this is governed under section 71 of Indian Contract Act, which says a person who finds goods belonging to others and takes them into his custody is subject to the same responsibility as a bailee, and hence the finder of lost goods has to take proper care of the property as men of ordinary prudence would take, and no right to appropriate the goods, and he has to restore the goods if owner is found. And also, according to section 169, the finder can sell the goods in the following cases: when a thing found is in danger or perishing in nature, danger of perishing; when the owner cannot with reasonable diligence be found out; when the owner is found out but he refuses to pay the lawful charges of the finder; and also when the lawful charges of the finder in respect of thing found amounts to two-thirds of the value of thing found, and hence all of the above is the correct answer. Now going to question number 23. A contingent agreement to do or not to do anything if an impossible event happens is: option A, valid; option B, void; option C, voidable; and option D, illegal. The correct answer is option B. Contingent contract is based on happening or non-happening of an event. Hence, there is an element or minute chances of happening of an event. In this case, the event is impossible to happen, and hence it is not contingent, and hence it is void. Question number 24. Sale by official receiver or liquidator of the company or finder of lost goods is: option A, valid; option B, void; option C, voidable; and option C, unenforceable. Finder of lost goods is already discussed, and official liquidator is appointed by the court in the cases or in the event of liquidation by the company, and hence it is also a valid contract. Question number 25. Which of the following is a contingent contract? A, contract of insurance; B, contract of doing impossible acts; C, marriage contracts; and D, wagering agreements. The answer is option A, contract of insurance. This is already discussed in the introductory session. A contract of insurance is a contingent contract because the insurance contract generally covers the risk of the insured on happening of some uncertain future events, and hence it is a contingent contract. Question number 26. The collateral event to a contingent contract would be uncertain event, certain event, either A or B, neither A nor B. The answer is A, uncertain event. The main contract is contingent, and hence the event collateral to the main contract should also be contingent in case of a contingent contract, and hence the option is, the answer is option A, uncertain event. And next we'll go to question number 27. A contract is not a contingent contract if the event is bound to happen, if the promisor has control over the event, if the event is part of the promise of the contract. D, all of the above. Correct answer is option D, all of the above. So given are the options of given options are the properties of contingent contract, and hence it is self-explanatory. Question number 28. Conditional contracts are called as dash contracts: absolute contract, contingent contract, quasi contract, and illegal contract. The correct answer is option B, contingent contract. Contingent contract is dependent on conditions of happening or non-happening of an event, and hence it is called conditional contract. Question number 29. A wagering agreement is essentially of contingent in nature, whereas the contingent contract may not be wagering in nature. The statement is option A, true; option B, false; option C, partly true; and option D, none of this. The correct answer is true. The reason is, in wagering agreement the outcome is not known and hence it is contingent, but in contingent contract it is not void, unlike wagering agreement, and hence the statement is true. Question number 30. A wagering agreement is void whereas a contingent contract is valid. The statement is option A, true; option B, false; option C, partly true; and none of the above. The correct answer is option A, true. It is self-explanatory because the wagering agreement is void in nature. Question number 31. A contingent contract to do or not to do anything or on happening of certain future event is option A, is never enforceable; option B, is enforceable only at the time of making it; option C, becomes enforceable immediately when event becomes impossible; and option D, becomes enforceable only on happening of that event. The correct answer is option D, becomes enforceable only on happening of that event. The reason is, till the event happens the contract cannot be enforced, as the contract is highly dependent on happening of the event, and hence it becomes enforceable only on the happening of the event. Question number 32. A contingent contract to do or not to do anything on the non-happening of an event, an uncertain future event. Option A is never enforceable; option B is enforceable only at the time of making it; option C, becomes enforceable immediately when event becomes impossible; and option D, becomes enforceable only on happening of that event. The correct answer is option C, becomes enforceable immediately when event becomes impossible. The reason being, since the contract is dependent on happening of the event, it shall be enforced only that event is impossible to impossible of happening. That is, the contingent contract to do or not to do anything on the non-happening of an uncertain future event. So in this case, unlike to the previous question, it is not dependent on happening of the event, it is dependent on non-happening of the uncertain future event. So in case of non-happening of an uncertain future event, the contingent contract becomes enforceable only if such event is impossible to happen, and hence immediately if it becomes impossible to happen, the contingent contract becomes enforceable, and hence the option is C. Question number 33. The performance of contingent contract depends on main event, B, collateral event, C, both an A and B, and D, either A or B. The answer is collateral event. The reason is, the contingent contract will always depend on some event which is collateral. That is, the main contract depends on an event. The main contract, that is the main event, the main contract depends on some collateral event. If such event is happening, based on happening, the result of main contract will change. That is, the enforceability of main contract will change. Either it will become enforceable or it will become non-enforceable, and hence the answer is collateral event. Going to next question. Question number 34. The event upon which performance of contingent contract must not depend upon the dash of the promisor. A. Mere will of the promisor. B. Act of the promisor. C. Rules of the promisor. And D. Principles. The answer is A. Mere will. Mere will is not a base to a contingent contract. There should be some collateral contract upon which the main contract is dependent, and hence the option is answer A. So the answer is option A. Going to question number 35. If A promises to pay B rupees 10,000 and if he so chooses, the contract it is a contingent contract. Options are option A true, option B partly true, option C false, and option D none of the above. The correct answer is option C false. This is because for a contingent contract, consideration is not a base for contingency. There should be a collateral contract which is a contingent. Also, a contract dependent on mere will of the promisor is not contingent, and hence the answer is false. Question number 36. A agrees to pay 50 if two parallel straight lines intersect each other. This agreement is option A void, option B voidable, option C valid, and option D illegal. The correct answer is option A void. This is because it is an impossible event and hence it is not contingent contract, and therefore the answer is void. Question number 37. A promises to pay B rupees 30,000 if B procures for him a title of Padma Shri. The agreement is A enforceable, B void, C valid, and D voidable. The correct answer is option B void, because this is a wagering agreement and hence it is void. It is not a contingent contract. It is a wagering agreement because based on the happening of happening or non-happening of an event, there is an outflow of money or money's worth, and hence it is wagering agreement. Question number 38. If claim for necessities is made to a person who is incapable of contracting, the supplier is entitled to claim the price from the property of such person. The options are A true, B partly true, C false, and D none of the above. This is based on claim for necessities supplied on quasi contract, which says if there is some necessities paid to person who is incapable of contracting, example minor or person of unsound mind, the supplier is entitled to claim the price from the property of such person, and hence the answer is true. Moving to question number 39. A person who has paid a sum of money which another is obliged to pay is entitled to be reimbursed by that other person, provided the payment has been made by him to protect his own interest. This rule is based on A contingent contract, B wagering agreement, C quasi contract, and D agency contract. The correct answer is C quasi contract. Law imposes quasi contract, and hence based on equity justice the person has to reimburse the other person if the payment has been made to protect his own interest, and hence the option is C. Question number 40. Where a person lawfully does anything for other person not intending to do it gratuitously and the other person enjoys the benefit, option A, the person receiving the benefit need not compensate the former. Option B, the person receiving the benefit should compensate the former. Option C, both A and B. And option D, neither A nor B. The correct answer is option B. The person receiving the benefit should compensate the former. Once again, this is based on quasi contract, based on equity and justice, and hence the person receiving the benefit should compensate the former. Question number 41. For a suit to succeed on the grounds of obligation of person enjoying benefits of a non-gratuitous act, the plaintiff must prove: option A, that he has done the act lawfully; option B, he did not intend to do it gratuitously; option C, the other person enjoyed the benefit; and option C, all of the above. The correct answer is all of the above. This is based on quasi contract, once again based on obligation of person enjoying the benefits of non-gratuitous act. Only if the plaintiff proves all the three conditions, he can succeed on this ground, and hence all the three conditions are important. Question number 42. A person who finds goods belonging to another and takes them into custody is subject to do the same responsibility as: option A, agent; option B, principal; option C, bailey; and option D, promisor. The correct answer is option C, bailey. This is already discussed, and hence there is no need of explanation. The correct answer is option C, bailey. Question number 43. If person to whom the money has been paid or anything delivered by mistake or under coercion must: option A, enjoy it; option B, repay it; option C, donate to somebody; option D, none of the above. The correct answer is option B, repay it. This is based on unjust enrichment principle. That is, if a person to whom the money has been paid or anything delivered under coercion or by mistake, he cannot enjoy the money or the property delivered or donated to somebody. He has to repay the money based on unjust enrichment. Hence, the correct answer is option B, repay it. Question number 44. Dash does not arise from any agreement of the parties concerned, but it is imposed by law. Option A, quasi contract; option B, contingent contract; option C, contract of sale; and option D, contract of bailment. The correct answer is option A, quasi contract. This does not require any explanation. We have discussed this in many illustrations, and hence no further explanation is required on this. The correct answer is quasi contract. Question number 45. Rights under quasi contract is available against the entire world. The options are: option A, true; option B, false; option C, partly true; and option D, none of the above. The correct answer is option B, false, because rights under quasi contract is available only against single person and not against the entire world. Hence, the answer is option B, false. Question number 46. Quasi contract is based on the principle of A, equity; B, justice; C, good conscience; and all of the above is option D. The correct answer is all of the above. Quasi contract is imposed by law based on all these three grounds. That is, it's a legal obligation which is created on the parties of the contract based on all the three grounds, and hence the answer is D, all of the above. Question number 47. The basis of quasi contract are: option A, valid contract between the parties; option B, prevention of unjust enrichment at the expense of others; option C, provisions contained under section 10 of Contract Act; and option D, existence of voidable contract between parties. The answer is option B, prevention of unjust enrichment at the expense of others. This is already discussed. Quasi contract is a legal obligation enforced by the law on the parties, and hence it takes unjust enrichments. That is, the party cannot take advantage of others rights without any justice, and hence the answer is option B. Question number 48. Sometimes a person finds certain goods belonging to some other persons. In such a case, the finder: option A, becomes the owner of the goods; option B, is under the duty to trace the true owner and return the goods; and option C, can sell the perishable goods if true owner cannot be found. The answer is both B and C. This is also already discussed. That is, a person, if a person finds certain goods belonging to some other person, He is under the duty to trace the true owner and return the goods. If he is not able to do so, and if such goods are in perishable condition, he can sell the goods, and hence the option is D, both B and C. Question number 49. An agreement to do illegal act is valid, void, voidable, and contingent. The answer is option B, void. This is a basic Indian contract which does not allow an illegal act to be performed by an agreement. This is in fact void at the initial stages itself. That is, at the agreement level itself, it is void, and hence it is void ab initio. Question number 50. Quasi contract and contingent contract are A, two different aspects, B, similar to each other, C, mutually dependent on each other, and D, mutually exclusive to each other. The correct answer is option A, two different aspects. This is because quasi contract is based on the principle unjust enrichment, and contingent contract depends on the happening or non happening of an event, and hence the option is A, two different aspects. With this, we have completed the review of contingent and quasi contract. In case if you have any queries, you may kindly send your email to queries@greymatteracademics.com. Thank you.